Hello. Everybody hear me? Okay, welcome back, folks. We're going to hang out for a few more. Let those that want to come back, come back. Okay, I think I got all my notices out again, so we'll see how it goes. Okay. Okay, that's Yeah, I gotta wait just another minute here, folks. I got the other meeting converting. I do not want to forget that before I get started here. Should be done any second now. Okay. Filed, and we are ready to go. All right. Well, thanks for stopping back, folks. I know sometimes I can get a little extensive and carried on, but I'm hoping you're following along in the simplicity, and we'll take this material in your own time and research it further, and not just take my word for it being this simple. But in the end, it really is. Everything's been entered wrong, and we can prove it simply because we don't have the actual status. And this is the one we were just talking about. Inspection by immigration officers, expedited removal of inadmissible arriving aliens, referral for hearing. See, we were an alien. We were treated as applicants for admission. Mom should have never applied if they didn't know what they were applying for, period. Under the next one, we see a lot allocation of immigrant visas, and the visas are things that foreign countries give you in order to come to their country, and most generally they're done under commercial terms and agreements. You can go as a traveler, as a tourist, but there's still commercial agreements made in arrangements thereof, where even as a tourist, you supplied a signature to operate as a trustee instead of a beneficiary. Waiver of job offer, national interest waiver, subject clause II. The Attorney General may, when the Attorney General deems to be in the interest or in the national interest, waive the requirements of subparagraph A, that an alien service in the sciences, arts, professions, or business be sought by an employer in the United States. All these jobs are asking for your expertise. Even McDonald's, you want to make paycheck, and that's the scale you can reach. They want your expertise. They want your limited expertise. The Attorney General shall grant a national interest waiver. Pursuant to Clause I, on behalf of any alien physician. What? What? You are shitting me. Think about this, people. With respect to whom a petition or preference classification has been filed. I don't need a physician. He who is whole is not in need of a physician. Again, not subject to your requirement of a physician. Why would I need an alien physician to concur with your physician? This isn't about physicians. This is about my physical preference. It has nothing to do with a physician with respect to whom a petition, a piece of paper, refers to. No correlation. I am my own physician. I determine what goes in this thing. Protection of foreign officials, official guests, and internationally protected persons. Isn't that person already supposed to be internationally protected? I mean, isn't it part of the welfare program through your health and welfare insurances to protect the mother and children? Isn't that child, that newborn child, even in your own codes, rules, and regulations, presumed to be a minor of the United States? Even if it's a minor of the state ceded its jurisdiction to the United States for that very same protection. So if you're a United States citizen, aren't you internationally protected by their own code? Why are they bringing codes against you? Doesn't make sense. See, contracts are not enforceable. They only go to arbitration. The only thing enforceable in contracts is breach of the contract. And that's an intentional will to breach the contract. Otherwise, you can quit at any time, saying you just no longer wish to participate. That's contract law. Just like the beneficiary doesn't have to accept the grant. It's trust law as well. Reporting requirements. Now notice this is under foreign relations. Sponsors must submit annual reports to the Department of State. Who's the sponsor? Well, that would be the guy that's on the other side of the investment scheme that the alien investor is investing with. He's the one that made the offer. He's the one that's sponsoring the contest, the competitive contracting. Applicability of reciprocity laws, equal consideration, equal benefit. If you did not think it was worthy of your efforts, do you have the right to say no? Anybody would, by reason and logic, answer that question as, yeah, I can dismiss it. I can say no. If it's not up to my standards, I can say no. So if it's adding unto or taking away from the word of God, I say no, because he says no. That's his will through me. That's the reciprocity. And if any detriment be incurred, it is to be suffered by all parties. So when they want to enforce those penalties, make sure all parties suffer those same penalties. Letter of authorization. Remember, I was telling you about that wildlife fisheries. Guess what, folks? Here we are at 50 CFR, letter of authorization. And it says Title 50-Wildlife and Fisheries. Now, I want you to remember that because I'm going to prove something to you here in a minute. Letter of authorization may be issued only to U.S. citizens. Only to U.S. citizens. Is required to conduct activities pursuant to any regulations established under 216-105. And here we are, specific. Not general, not presumed, not assumed, not implied, but specific. Letter of authorization. Request for letters of authorization shall be submitted to the Director, Office of Protected Resources. The person is a resource. It comes from a source, and they resourced it. The information to be submitted in a request for an authorization will be specified in the appropriate subpart to this part or may be obtained by writing to the above named person. Issuance of a letter of authorization will be based on a determination that the level of taking will be consistent with the findings made for the total taking allowed under specific regulations. Telling you that they are taking shit. It's the only way they can acquire things, which is the taking of things. So at the hospital, the level of taking is the data elements. They need the data elements. They don't need the baby. They can capture him when he's an adult and able to defend himself. Endangered wildlife. Wildlife. What is wildlife? Wildlife means the same as fish or wildlife. So we go down to fish or wildlife means any wild animal, whether alive or dead, including without limitation any wild mammal, bird, reptile, amphibian, fish, mollusk, crustacean, arthropod, coelenterate, or other invertebrate, whether or not bred, hatched, or born in captivity, and including any part, product, egg, or offspring thereof. Mammalia. You got mammary glands. You got mammary glands. Think about that, folks. This here is Title 50. Wait a minute. War and national defense. I thought Title 50 was wildlife and fisheries. Yeah, here it is. Title 50 of the U.S. Code, and not the Code of Federal Regulations, is war and national defense. So let's look up 50 CFR. Nope, it says CFR, Title 50, wildlife and fisheries. You see how their code is inconsistent? Acquisition of and expenditures on land for national defense purposes. And they need every arm and leg of every infant born in every infant ward for the infantry. And it's through the acquisition of data elements at the level known as a customs facility called a hospital, a military post. Acquisition and expenditures of land for national defense purposes. And you can go through here and read it. Look, it says repealed, omitted, repealed, repealed, omitted, transferred, omitted, repealed. You go through and you read those. Authorized Secretary of War to institute condemnation proceedings for acquisition of land, to purchase land and accept donations of land. This is where I get my language, folks, because I do my research farther than just repealed. Oh, well, I check the notes and find out what it was written about. This is what led me to the 1900s, early 1900s, legal notices in the papers wherein the proper entry was made into the land records. Uniform Code of Military Justice. We are talking about a martial law, which is a provisional law, and here we have the general provisions repealed. Defined terms used in this chapter. 301 of Title 10 and 101 of Title 10 is where they sit now. So if we go to 10, USC 101, it should have a title definition. There we go. Definitions. If we replace it with an 801, it should too come up with another set of definitions. This one here says Article 1. And here we go, Judge Advocate General. When these administrative courts refuse to review the determination that you've made about the judicial elements, data elements that were entered wrongly in error, and they refuse to act upon that, go straight to the Judge Advocate General. Condemn their words. They are wrong. Their words are wrong. Even if you had part in doing that, I accept my part in it. Please forgive me. I repent for my mistakes, and I give you this offer to repent for yours in peace. I forgive you. Forgive me. Let's go and remove all that bullshit from the record. It's hurting everybody. The Navy, the Marine Corps, and the Coast Guard. Remember what I said earlier? The Navy is the one that operates in Admiralty, and their extension is the Coast Guard to guard the coast, and the Marine Corps inland. So then the next one repealed again, 556, 551 through 556. And that was general provisions. Courts martial jurisdiction. Courts martial is a civilian venue. It's for the civilian officers of the executive civil service. The military tribunal is for those that are actually military personnel. So here we have the specific regulations for all petitions. Everything's just a petition. That's all it is. It's just paperwork. And all they have the right to do is petition for it. They cannot enforce it. The only way they enforce it is by you letting them, through your fear. Get out of the fear and present the truth to them that they can't rebut. I'm sorry, I made mistakes, and here's your mistake in trying to enforce it. I can't qualify this document any longer. I can't give signatures. I can't. That's why I don't sign. Not qualified. Not my petition. 50 U.S.C. 4304, licenses to enemy or allied insurance companies.
Fucking bullshit.
Okay, and this is where I want to make the important notice here. Like I said earlier, there's those three insurance schemes: marine insurance, inland marine insurance, and motor vehicle insurance. Motor vehicle insurance for common carriers who have residential addresses listed on the very instrument they are using against you, the driver's license or ID, name and address. And it is only associated through a number that is hidden in the background, which you're qualified to use under 19 CFR 149.3. You're qualified to give a number in lieu of the name and address. If you're qualified to give a number in lieu of a name and address, and therefore not required to give the name and address, why sign? Again, verifying just knowledge means I don't have to give a signature. All I got to do is clarify that the name and number identify the record, and the record is wrong. I'm not qualified to give a signature to validate the assessment of the record. Your assessment is wrong. It cannot be validated. Again, it's an insurance scheme, and we need full acquittance and discharge under 50 USC 4305. We need to suspend the provisions of those regulations to me because they're not providing me squat. Relating to ally of enemy. And the enemy is the one that is entering documents into the record, placing a debt against the United States as a corporation, but isn't incorporated yet, and thus must be operating in a tax scheme. And the state will prove this and charge you in the tax scheme. Regulation of transactions in foreign exchange of gold or silver, property transfers. Every time you sign a document, that's what you're doing. You're making a transfer. You're operating in the position of an attorney. Vested interest, enforcement, and penalties. B2, clarifying, wherein no person shall be held liable in any court for or in respect to anything done or omitted in good faith in connection with the administration of or in pursuance of and in reliance on this subdivision or any rule, regulation, instruction, or direction issued hereunder. See, I'm not following their rules or anything. I'm giving them a directive. I'm the director. Period. I'm going to give them the directive that, sorry, the record's wrong, and you have to admit it, because if you don't, I'm going straight to the JAG. Okay, it says somebody's got their hand raised. Go ahead, Kevin.
Yes, sir. What's going on, Mr. Keith? How are you, brother
Good.
Keith? And everybody else in the room, how y'all doing? I relate to what you're saying right now as far as you being a director. I had a child support issue, and I sent a small little note just letting them know that I don't consent to I don't consent to the consent order because it doesn't even say child support order. But I told them I don't even consent to the order no more, and I want them to remove or terminate the order, the consent order, due to the fact that my rights are protected via the state and the federal constitution. And instead of sending it to like an agent, I sent it to the head. I sent it to the director of child support. And sure enough, 20 or 30 days later, I got my remedy. Just for sending out a letter just telling them I don't want to participate anymore.
Yep, and that's as simple as it gets, folks. It's all contract law. And if you want to be the beneficiary, you're not required to do anything. So don't sign.
Yeah, so just to say that we are the directors.
The remedy's already there in trust law. You just have to enforce that trust law above the corporate contract law. I'm not party to the contract. Sorry.
That's all I wanted to say. Next.
Yep. And that's awesome because again, that's just reaffirming that all you have to do is give them notice and knowledge. Once they have notice and knowledge, they're done. I received while I was sitting in jail in my last case, 5.5 years ago, that child support, what they did, they withdrew all license sanctions. What they'd done is they'd gone through and because I refused to pay child support, they sanctioned all my licensing, driver license, fishing license, hunting license. I don't care. I'm not qualified for those licenses. So I filed my documents in that last court case, and then all of a sudden I got a thing back from the child support services saying that they withdrew those sanctions. Now, why would they do that? Think about it. It's contract law. They want me to contract with them again. And I know contract law well enough that if there's no sanctions, then it's an open contract still. If there are sanctions, then they finalize the contract. It's what they did to Cuba. Think about it. So anyway, we're talking about giving them their remedy as well. We want our remedy of not being held liable in any court. Give them their remedy. We're the only ones that can do that. They are not willing to correct the record because the only way they make their existence is on the presumption of the record. As long as that record presumes as much as possible, they can make as much as possible. Restrict their income. Quit giving it to them. Alien property custodian. General powers and duties. That sounds like attorneys. They're the property custodian. They're the ones that hold that property, right? They can't own it. They're just the custodian. It's saying they're custodians. Who are the custodians? This is the military code, folks. It's the military. Holds all property in abeyance until a rightful owner comes forth and makes a valid claim. Pure and simple. List of enemy or ally of enemy officers, directors, or stockholders of corporations in the United States. Acts constituting trade with enemy prior to October 6, 1917. Remember, I talked about those early legal notices. Conveyance of property to custodian. Voluntary payment to custodian by holder. Now, wait a minute. If they're the custodian, isn't custodian the holder? How come all of a sudden now we have a custodian and a holder? Acts under rule or order, rule or regulation. Contracts, mortgages, or pledges against or with enemy or ally of enemy. This is the birth registration. It was a pledge. And the contract was an abrogation and suspension by limitation. Somebody want to say something? Okay, I'm continuing. The claims to property transferred to custodian. The claim is to the original document that mom signed, because that's the initial entry into the records of data elements that were unlawfully converted to a corporate status without any further knowledge or education being given as to how it's used. Okay? You don't give an 18-wheeled rig to a 10-year-old child to use. You put it in the custody of a trustee who has a responsibility to turn that property over to the beneficiary when the beneficiary can use it without legal terms. It's not a legal thing once the custodian has property in his vested interest because he's being compensated for one day to transfer it to the beneficiary. He's not then to turn around and put the beneficiary through a bunch of tests. This is the problem. People want to take upon the convenience of modern things. Keep it simple and learn how to use things in the right manner first, and then you can learn how to use these modern things in your adult age. Notice of claim filing. That was the initial filing, that I'm talking about again. Return of property, property rights, suits to recover. We're not in a suit to recover. We're removing all the suits that were enacted upon without proper incorporation. Sale of claimed property in time of war or during national emergency. There's never been a thing where time since Congress walked out Sindai that we haven't been in a national emergency. Period. (50) U.S. Code 4310 acts permitted applications for patents Why are you applying for patents when things are already patent? What is done is what ought to be done. There is nothing new under the sun. Again, we're just correcting the record. I don't need to apply for a patent. In fact, applying for a patent wherein I have to give you specific elements that are private according to my invention that you get to turn around and publish in the World Forum so everybody else can repeat and make money off of. That's just stupid. If I want to keep it private, why would I give it to you when you plainly tell me you're going to publish it? That's just dumb, people. Or registration of trademarks or copyrights. Again, registration or trademarks or copyrights is a pledge to let them use it. A copyright, in fact, is a copyright by itself. It does not take an enactment of any kind of law. It is patent. Payment of tax in relation thereto. In relation thereto what? Applications and registrations. Not the patents, trademarks, or copyrights, but the applications and registrations. Licenses under enemy-owned patent or copyright, which can only be done by Congress. Congress shall lay and collect taxes and duties. Therefore, they're the ones that allow for the licensing to collect taxes and duties in the commercial fashion and then be enforced through a military branch. Statements by licensees. Did you forget to put that qualifying statement in there certifying that you in fact did take an oath to perform the functions of office and can take upon the commercial licensing thereof of a person incorporated with contract of the United States under Federal Acquisitions Regulation 52.212-5, wherein contract terms and conditions are required to implement those statutes and executive orders, so long as there are commercial items attached? If you haven't, then ain't none of it valid. And I didn't do it, and Mom didn't do it when she established that corporation either, or when she participated in that. It was never done. Certification is false, period. Property transferred to alien property custodian. And they're the ones that hold it, and they will gladly give it to you. That means they are holding evidence in, on, and for the record of tortious wrongs, unconscionable contracting, breach of trust. 4313, statements by masters of vessels and owners of cargoes before granting clearances. The clearance was granted not by the owner, but by somebody else who had a vested interest in it as a public trustee because they were going to get paid to do so. They didn't give a rat's ass about the other part. The only reason they did it is because they had to do their job. I'm just doing my job. Again, plain stupidity. All of these people are incompetent, and I pointed it out many times. These doctors take an oath, a Hippocratic oath to Apollo and the Greek gods. Can't read plain English, and yet profess to have gone to medical school for 18 years and know the medical profession that uses the English language while using Latin medical terms. Malika! How you doing,
Sorry about the
sister?
music. I'm doing well.
Great. Glad you could join us. We've only got just under 3 minutes left, so I'm going to cut it now. I still got more windows, so I'm going to open the room again. This is the second session. I already did one session. I'll just open it for a third session. And it's all right to do that because that keeps me in those 40-minute sessions easier to log on my computer, easier to set them up for people to watch, blah, blah, blah. So we'll do the final session. I've got more windows to open up, but Kevin, you still got your hand up. If you got any questions, feel free.
I just put it up just now. When you were talking about the incompetency, I work with these people, so I'm very aware of how incompetent they are. And I look at these people like, man, it's amazing. Y'all can't read what you would call plain English. And then when you you define the words for them or you define the the term of its use, they still look at you as though, oh, I'm just doing my job, as though they don't have, the sense enough to even wake up after reading the definition.
Yeah. And that's why, and that's Malika just popped on, and that's one of her favorite things as well, is every time we go to sections in these codes and start looking things up, the first thing we should look at is the definitions. Find out what they're using for their definitions. And then go to 1 USC 1 and point out that that definition actually means this, and this. Just like I pointed out with the beginning here, the entire executive civil service consists of attorneys, and by signature, you are in fact in the position of attorney, not the person, but the position, and therefore the presumption rides that you are in fact an attorney of the public trust transferring public property. That's a pretty damn big assumption, but it's there. I'm gonna open it up just to show Malika again real quick. Entire executive civil service, Malika, check this out. First off, it starts out positions of chaplain and chaplain assistant, not in person, but they're talking about the position. And then it says reserved. And then it says positions to which appointments are made by the president without confirmation by the Senate. So we're not talking about Senate or House, or we're specifically talking about just the House. And then it says attorneys. Law clerk trainee positions, appointment under this paragraph shall be confined to graduates recognized of law schools. Everybody synonymously acting as an attorney in the position of an attorney every time they transfer something, whether it be a Federal Reserve note, an electronic card, or a signature